Yes. 16.
Anyone here in 31?
I'm in 31.
Yeah, Mr. Rao has to go on, no? Yes.
6.
Yes.
Your Lordship has had the benefit of substantial arguments, Mills. They have a detailed written submission. I appear for the Digital News Publishers Association.
IA 2199.
IA is 2199.
IA is 1299.
No, 199. 2025.
You being briefed by Mr. Datta? Oh,
Datta is omnipresent.
No.
Mr. Datta is all the three interventions are by you.
No,
Only two.
All right.
I was telling Mr. Datta, Mills, the irony is that somebody who knows the field is instructing somebody, at least speaking for myself, who's still trying to figure out whether I'm copying right or wrong. So therefore,
Yes.
Mills, because your Lordship has had the benefit of substantial arguments, I'll try and keep it very short. Because I've tried to summarize the basis of my submissions into a 4-page note. I'll quickly run through that. Our submissions are already on record. They're far more detailed. If your Lordship will just permit me to quickly run through the broad heads and then I'll just refer to a few. Principally, my submission is that somewhere along the way, the understanding that I am allowed to take your content and use it in an electronic medium for the purposes of doing what according to me is training my own software is fair dealing within the meaning of the Act. This is a crucial aspect of the statute, particularly in light of the amendment that comes about a decade and a half ago. And according to us, the very fact that you store my product or convert my copyrighted material into any other form and store it in a medium, even if it be transient, is enough to demonstrate that you are infringing my copyright.
Right.
That is evident from a plain reading of the statute. That's the sum and substance of what I want to spend time on. But just running through the broad points. Item number 1, what is worth copying is prima facie worth protecting. That's why an exception must be read strictly, whereas the right must be read expansively, particularly because, admittedly, this is a consolidating statute which encapsulates the entire gamut of the law of copyright. So there is no common law, as Mr. Lal has mentioned. The second argument was it's available in the public domain. That, of course, merely because it's available for the public domain does not mean that I have waived copyright and I have lost what Section 14 uses, the exclusive right to authorize, to do or to authorize somebody to do A, B, C, D, E. Well, then 3, and this is what I will spend some time on today, a distinction between an infringing copy and a lawfully acquired copy, because your Lordship recalls the American judgment that Mr. Lal was reading, where one of the defenses and one of the exonerating factors was you went and bought the book, so therefore you did not rely on a pirated version. According to us in India, that makes no difference. 4 is, the act of scraping itself is an infringement within the meaning of our statute. 5, reproduction or storing, that's the other aspect that I will spend some time on, even at an intermediate step, without consent, is infringement under 14, 1A. 6, Mr. Sibbal in an extremely lucid manner explained the functionality of how ChatGPT works and how it breaks it down. Our submission simply put, you can call it token, you can call it vector. At the end of the day, if I am able to demonstrate that you've taken my piece, it's what we used to do in college. One book, various chapters would get distributed to various people. Ultimately, if we all have the ability to put the chapter back or an extract back, which is a substantial extract, that itself demonstrates that you are infringing. So you can use any type of technology. If at the end of the day you can reproduce my content, and there are admitted instances of regurgitation, the answer, of course, was the submission was those were glitches. We have now rectified that, and we are all dealing with this at an intermediate stage. I am only on the question of law. The other is between the plaintiff and the defendant. So, what is the principle that one would apply from an Indian copyright?
Digital news publishers would include, give some name of your members.
I'll give your lordships that. HT Media, Times of India, all of us. Each of us, and my application has a broad breakup. If your lordship will just have that for a moment, just to give your lordships the kind of content that we all own. This is at page 15 of my IA. Because one of the other side alleys that we keep getting lost in is news, therefore facts, therefore limited.
So you're concerned with news, no?
But I am also concerned with not just news. I have content, I have literary content, I have stories, I have interviews, etc., etc.
Yes.
So, therefore, page 15, if your lordship has.
Yes.
My literary works, for instance, news, current event stories authored by journalists, etc. These are original literary works based on the form, manner, and expression of each such news story. And similarly, opinions and op-eds, human interest pieces, then there are photographs, etc. Well, those, of course, are in a different bucket, but just for now, I'm sticking to the first bucket. So, ultimately, every case of infringement, we'll have to test what is the copyrighted work on the right side, and then, of course, but purely coming back to my note, and then, your lordship will see 7, the issue of training cannot be considered in isolation. Again, given that the process of training itself involves certain technological processes, use, storage, reproduction of the works input into the software is used for commercial purposes for selling output. So therefore, the other thread is where the exception under the statute carves out and says these shall not amount to infringement. A reading of the provision indicates that those are really for private limited use and they are not intended to be disseminated broadly. Why? Because if everybody can get access to my work in the public domain, then somewhere along the way, the incentive to come to me or to the source gets diluted. And I flag that particularly because if your lordship realizes we are now increasingly in a space and law must keep pace not only with technology but also keep pace with time. We are at a space where everything is really a summary. So therefore, I don't have the time to read a full newspaper. I have in shorts now. Even NDTV, for instance, has an app which will now give me a blip. So if the blip ultimately takes me away from the original source, if I am the author, I have the ability to authorize a blip and make the blip. But if you take the blip, then I am bleeped out.
Anyway, like we said, no fact specific.
Absolutely, which is why I said, in principle, that's why the law says, and which is why 51 and 52 must be read. And then, of course, para 8 is, we say, effectively the principle of substitutiveness, because at the end of the day, if it is substantially similar or it serves the purpose that the original work does, then, my rights are infringed, and that's the injury. This is really the broad play. I request your lordship straight away, to first just have the act. And may I just show your lordships a few provisions from here. These first have 14, because that's the starting point. And I'm cognizant that your lordship has seen that on numerous occasions. But before that, if your lordship will, I'm sorry, I should have started with that. These have the preamble to the act. It says it's an act to amend and consolidate the law relating to copyright. It's a consolidating statute.
Yes.
There are 3 very useful paragraphs by His Lordship Justice Nariman, which explain the entire gamut of this statute. Just give me that. I'll just set that out, and then take your lordship to the provision. Engineering and Analysis Center. Just hand over the copy.
By compilation.
That's okay. We'll come to that. Would your lordship permit me to just show your lordship 14 while my friend identifies the compilation? Please straight away have, Millet, if your lordship will have, the discussion on the Copyright Act. This, of course, arises in the context of taxation of software. Please have para 38 onwards.
38.
Yes, please. 38 sets out the act, sets out the relevant provisions of the Copyright Act. We'll come to those provisions eventually. But please now see, Millets, how the court addresses what the act stands for and what are the contours of it at para 39.
Yes.
Should
Yes.
The reading of the aforesaid provisions leads to the following conclusions. Under Section 2 of the Copyright Act, a literary work includes a computer program, and a computer program has been defined under 2 FFC to mean a set of instructions expressed in words, codes, schemes, or in, please just note, in any other form capable of causing a computer to perform a particular task or achieve a particular result. That's, of course, in the context of computer programs. I'm flagging that with reference to the vectors and that argument, Millet, that Mr. Sibal makes. Though the expression copyright has not been defined separately in the definitions section of the Copyright Act, yet Section 14 makes it clear that copyright means the exclusive right, and it is emphasized, subject to the provisions of the Act. So all limitations must be read in only from the statute and nowhere else. To do or authorize the doing of certain acts in respect of a work. And that is the privilege that the statute grants me. Why? Because it encourages creativity and allows me to monetize my creativity, my skill, my labor.
Right.
When an author in relation to a literary work, which includes a computer program, creates such work, such author has the exclusive right, subject to the provisions of the Copyright Act, to do or authorize the doing of, please just note, several acts in respect of such work or any substantial part thereof. In case of a computer program, 14B specifically speaks of 2 sets of acts, the 7 acts enumerated in clause A and the 8th act of selling or giving on commercial rental or offering for sale or for commercial rental any copy of the computer program. Because the act says it must not be an infringing copy. In fact, it must be lawfully acquired. I'll show your lordship that from the section. Insofar as the 7 acts that are set out in subclause A are concerned, they all delineate how the exclusive right, that is with the owner of the copyright, please just note, may be parted with, i.e., if there is any parting with the right to reproduce the work in any material form, and I will just emphasize that, in any material form. So merely because you buy my book, it doesn't mean you can scan it and start circulating copies. In fact, according to me, even the act of scanning per se may be infringement, but for the exception. The right to issue copies of the work, to reproduce the work, the right to issue copies of the work to the public, not being copies already in circulation. The right to perform the work in public or communicate it to the public, the right to make any cinematographic film, so and so, the right to make any translation of the work, again, Malas hemmed in by a caveat in the statute, the right to make any adaptation of the work, or the right to do any of the specified acts in relation to a translation or an adaptation. That's 41. In essence, such right is referred to as copyright, and please note, includes the right to reproduce the work again in any material form. Issue copies of the work to the public, perform the work in public, or make translations or adaptations of the work. This is made even clearer by the definition of an infringing copy contained in 2M of the Copyright Act, which in relation to a computer program means reproduction of the said work. Thus, the right to reproduce a program and exploit the reproduction by way of sale, transfer, license is at the heart of the said exclusive privilege. And then please just have paragraph 43. Importantly, no copyright exists in India outside the provisions of the Copyright Act or any other special law for the time being. Of course, it is section 16 of the Copyright Act. When the owner of copyright in a literary work assigns wholly or in part all of the rights contained in 14A for consideration, the assignee becomes entitled to such rights and shall be treated as the owner. Because if your lordship will just jump to placitum D in the interest of time, in the context of licenses. When such a license is granted, copyright is infringed when any use relatable to the said interest or right that is licensed is contrary to the contentions of the license so granted. Infringement of copyright takes place when a person makes for sale or hires or sells or lets for hire or offers for sale, so and so. Please now note, so as to affect prejudicially the owner of the copyright. 51B of the Copyright Act. Importantly, the making of copies or adaptation of a computer program in order to utilize it for the purpose for which it is supplied, well, that does not constitute infringement. I'm just flagging this. Now your Lordship will only see 52(1)(a). A is independent. Your Lordship will just ignore that for now. Please straight away now come to 14 for a moment.
40?
114.
Oh.
My friend wants me to just show your Lordship's paragraph 128.4 also. I believe that was shown, but the conclusions, 4 and 5.
Page?
This will be at page 437. In fact, 3 says, parting with copyright entails parting with the right to do any of the acts mentioned in 14. Transfer of the material substance does not itself serve to transfer the copyright therein. Transfer of the ownership of the physical substance in which the copyright subsists gives the purchaser the right to do with it whatever he pleases, except the right to reproduce the same and issue it to the public, unless copies are already in circulation. And other acts mentioned in 14, but please see 128.4, which my friend wants me to read. A license from a copyright owner conferring no proprietary interest on the licensee does not entail parting with any copyright and is different from a license issued under section 30, which is the license which grants the licensee an interest in the rights mentioned in 14A, 14B. When the core of a transaction is to authorize the end user to have access to and make use of the licensed computer software product over which the licensee has no exclusive rights, no copyright is parted with, and consequently no infringement takes place, as is recognized.
128. Yeah, that's selected. Prevents.
So, the principle is this. Admittedly, here, I am told I don't need your license. It's available in the public domain. I am only crawling, and I am not storing is the submission that is made. Now, the other is there was a side alley on legitimately acquired. Please just have 14 for a minute. What is the gamut of my right as a copyright holder? Because this is a comprehensive consolidating statute, for the purposes of this act, copyright means the exclusive right subject to the provisions of this act. So the only limitation has to be found within the statute. To do or to authorize the doing of any of the following acts in respect of a work or any substantial part thereof, namely, in case of a literary work not being a computer program, please just note to reproduce the work in any material form, including the storing of it in any medium by electronic means. So if I have the exclusive right to authorize you to do this or not to do this, the fact that you pick it up from the public domain, the fact that you use it to train, the minute you download without my authority, you are infringing my exclusive right. Then, of course, comes the issue of to issue copies of the work to the public not being copies already in circulation. I ask myself, if ultimately the object of your entire exercise is to make available my work or what my work seems to stand for, and we can squibble over the argument of whether I have taken extracts, etc. But as recently as yesterday, I asked a colleague of mine to essentially pull out an interview and ask ChatGPT about that interview. ChatGPT not only excerpts that interview, but says if you want any further excerpts, please let me know. But those are all factual, I'll keep that aside. We are purely on the question of law. Then your Lordship sees, in case of a computer program, your Lordship will ignore all of that. Please now come to the definition of infringing copy in 2M. Yeah, that's okay. That is that. What is an infringing copy? Infringing copy in relation to a literary, dramatic, musical, so-and-so work, a reproduction thereof, otherwise than in the form of a cinematographic film. But please see, the end after 4. If such reproduction, copy, or sound recording is made or imported in contravention of the provisions of this act. So any reproduction which is not consistent with what the act authorizes or permits is an infringing copy.
Right.
And that is what is the consequence of an infringing copy being available? Please just have section 55 for a minute. And that's where perhaps the statute tries to balance knowledge and my interest.
Sorry, where?
Section 55. Because these are civil remedies for infringement of copyright. Where copyright in any work has been infringed, the owner of the copyright shall, except as otherwise provided by this act, be entitled to all such remedies by way of injunction, damages, accounts, and otherwise, as are or may be conferred by law for the infringement of a right. But please see, Mullah, the only exception under the proviso, provided that if the defendant proves that at the date of infringement he was not aware and had no reasonable ground for believing that copyright subsisted in the work, the plaintiff shall not be entitled to any remedy other than an injunction in respect of the infringement and a decree for the whole or part of the profits made by the defendant by the sale of the infringing copies as the court may in the circumstances deem. What is the bottom line? Infringing copy is something that cannot be reproduced except in accordance with. 14 is my absolute right to direct, authorize reproduction in any medium. And 55 says, if you don't have reasonable grounds, I am anyway entitled to an injunction, but I am also notwithstanding the fact that you may not have reasonable grounds, I am entitled to have you part with profits. If that is the lay of the land, then unless my friend tells your lordship and persuades your lordships to say per se in news, there is no copyright. I ask myself, which is not their case, fortunately, they say, and I also concede that because news is this agglomeration of facts and opinion, opinion, expression, etc. are protected. Your lordships have seen what the Supreme Court, the US court in Cadre says. I'm not going to repeat what Mr. Lal has read. But the bottom line is, I am then entitled to protection. And then quantum, etc., then becomes an issue of trial and adjudication on a case-to-case basis. It's in that backdrop, if your lordship will now come back to my note for a moment. Well, serial number 2, your lordship will just make note of the judgments and the extracts. I'm not the references. I'm not going there. Please have para 3. Now I come to the core of the issue, one part of the core, as it were. The explanation to 51A of the Copyright Act, in effect, excludes storage of infringing copies from the purview of fair dealing. Let's please have 52 alongside. Then we say that this is in fact a somewhat drastic difference from the law elsewhere. So in a statute where I have an exclusive right, the law says certain acts not to be infringement of copyright. The following acts shall not constitute an infringement of copyright, namely, firstly, a fair dealing with any work. Implicit is your dealing must be fair. Not being a computer program for the purposes of private or personal use, including research. Because the first submission would be the fact that you are ultimately a body corporate, which for all practical purposes is using this to monetize, at the end of the day, can never be private or personal, especially because your end result is
extensively argued.
Absolutely. So not going there.
Yes.
Then your lordship sees, well, it's only the explanation for a minute, and that's the point that I wanted to make. The storing of any work in any electronic medium for the purposes mentioned in this clause, including the incidental storage of any computer program, which is it not itself an infringing copy for the said purposes, shall not constitute infringement of copyright. So unless, so therefore an infringing copy is something that is reproduced without my consent, because I have the authority. The minute you store my material, even if it is transient, and that's why I'm at the risk of reading it again, the storing of any work, so I'm asking myself, why was the explanation required? Because otherwise the storing of a work would be infringement. The storing of any work in any electronic medium for the purposes mentioned in this clause, including the incidental storage of any computer program, which is not itself an infringing copy for the said purposes.
So we ignore this including part, no? Because it's not computer program.
No, yes, Minister. Yes, Minister.
So you're concerned with the latter part of the earlier part of the sentence.
Yes, absolutely. Any work. The storing of any work in any electronic medium shall not constitute infringement of copyright. But storing and reproduction are two very different things.
Right.
And that is why,
This
so
is, obviously, this is all the counsel appearing this side clearly make out a case for storing also amounts to infringement.
storing, yes, reproduction separately.
Besides reproduction,
Absolutely.
right.
Then, your lordships will see where there is a carve out, and please just have my note alongside. The term infringing copy is different from the term lawfully acquired used in the UK CDPA, or lawful access found in text and data mining clauses. 2M, I've shown your lordships that. Consistent with exclusive rights granted to the copyright owner. Now, what is the object, where the law says that if you have lawfully acquired something, you can use it for ABCD. Our statute, fortunately, makes that distinction. Please just have first section 2FAA.
Distinction between?
Lawfully acquired is the argument that one makes to say that if I have lawfully acquired a work, then I am entitled to do a few other things. We say, where the law allowed you to use a lawfully acquired work for particular purposes, otherwise it would constitute infringement. The law actually clearly stipulates. So 2FFA, your lordship will see, commercial rental,
Two FFA.
FAA.
Yes.
My case is that otherwise OpenAI is going too far. I'm sorry,
What?
That's nothing, I'll move on. I'm sorry. I was just making a play on FAA. So, I'm sorry. So, commercial rental does not include the rental, lease or lending of a lawfully acquired copy of a computer program, a sound recording, a visual recording, or a cinematographic film for non-profit purposes by a non-profit library or a non-profit educational institute. Similarly, your lordship will have section 30. This your lordship notes is an introduction in section in 2012 by virtue.
So what's the connection between this section and the lawfully acquired? It uses lawfully
Absolutely,
acquired. Okay.
absolutely. So where the statute allowed somebody to use something that was, just to flip it, if I was using a pirated copy and I was renting it, would I be infringing? If I was using a lawfully acquired copy but for a profit-making library or a profit-making educational institution, would I be infringing?
All right.
So therefore, it all ties back to the same principle. I have a bundle of rights. Those rights are exclusively vested in me. The privilege is subject to limitations which the statute contemplates. The legislature makes a careful distinction between various carve-outs. The implicit thread is most of those are for private or personal or in the larger public interest uses, but they definitely don't serve to address a situation where somebody is diluting my right by effectively making it available to the world at large.
Right.
Yes. And that limitation comes in 2012. Please then have 32(6) for a moment. Just to give your lordships another instance where the statute contemplates this. And I will end with saying that the statute also has a remedy where somebody believes that my work is essential, is being deliberately withheld, or I am asking for something that is more than it should be worth. The statute has a mechanism of compulsory licensing. Your lordship will see that. So 32 is license to produce and publish translations. Please just have, in the interest of time, please just have subclause 6. The provisions of subsections 2 to 4, insofar as they are relatable to an application under subsection 1A, shall with necessary modifications apply to the grant of a license under subsection 5, and such license shall not also be granted unless a translation is made from a work lawfully acquired. So therefore, all of this again, why? Because if it is lawfully acquired, then you have my authority and my permission. And that again has a statutory basis for you to take that further. Then your lordship will have section 65 capital A to B.
Section
65, 65.
65A, capital A. 2B. So let's 65A says protection of technological measures. Any person who circumvents an effective technological measure applied for purpose of protecting any of the rights. This is that, well, it's where you use, the allegation was that they use something called robot, etc. to scrape through and avoid paywalls. Please have 2 subclause B, doing anything necessary to conduct encryption research in using a lawfully obtained encrypted copy. So even to do research on my product, you have to first obtain a lawfully acquired copy. So you have to buy SEC online to be able to crack it in the privacy of your home for research purposes.
Okay.
Therefore, please come back now in that backdrop to 52. So, Manoj, which is why ultimately, when your lordship says the following acts shall not constitute an infringement, what is an infringing copy must be noted, and more importantly, Manoj, if your lordship will see subclause AA for a moment. Making of copies or adaptation of a computer program by, please note, the lawful possessor of a copy of such program from such copy. So I have a right to it in the first place.
But that's A is not relevant, no?
No, I'm just making the point that the legislature has
No,
a...
so 52 1A, does it use the word lawfully acquired
No,
or no?
it says a fair, no, it does not. It says a fair dealing with any work not being, because it says it shall not be infringement for the purposes of this act. So therefore, Manoj, the act notes that what is infringing is something that you are not authorized to do otherwise, or that you have not
That
lawfully
doesn't
acquired.
mean that anything which is not lawfully acquired,
acquired would be
should
infringing.
Yes.
Has to be. Then, Manoj, if you make a copy which is per se infringing in terms of 2M, that would also be proscribed by 52. So you can't open the gate to a free pass with a stolen key. Effectively, that's the sum and substance of the submission. But just to make that, take that thought forward, if your lordship will see, the thread is, Manoj, AA says lawful possessor of a copy. Then your lordship will see AD, making of copies or adaptation of the computer program from a personally legally obtained copy for non-commercial personal use.
No, but this cuts both ways. No, the fact that for a computer program all these things are provided,
Yes.
it's not there in 52A, would lead that the omission is intentional.
Oh, I'm so grateful.
Yes.
In fact, that's precisely why, Manoj, please see, what is proscribed is, it says fair dealing with any work, not
Right.
being a computer program,
Right.
for the purposes of private or personal use, including research. Therefore, Manoj, the first cut is what is fair dealing if it is not private or personal at the end of the day.
No, so you're entitled to argue that it's not private or personal.
Absolutely.
Right.
And therefore, and in any event, I'm entitled to also argue because of the explanation that if you are using an infringing copy, then in any event, Manoj, you're not covered by the act. Because storage per se is infringement, reproduction is an infringement. And if you therefore crawl my web,
Excuse me, please. No such. You'll have your turn. You'll have your seat. Yes.
so Manoj, the proposition is only this. If the thread of the statute is my rights are sacrosanct, a carve out of my rights must be read in a limited manner. My privilege that is granted to you by statute is to do something in a fair manner for private personal use, including research. The explanation says storing by itself of an infringing copy would be infringement per se. The only carve out is storing of any work in any electronic medium for the purposes mentioned, including the incidental storage, which itself is not an infringing copy, shall not be infringement. So if you store an infringing copy, you are automatically infringing. Now, if the admission is, I have taken from the World Wide Web, I don't have a license to take it. I have stored it, albeit for a transient moment. And in fact, there is case law, which my note refers to, which actually says, even if you store for a transient moment, that itself is infringement. What is the gamut of, and which is why, what is the net result of all of this? Because we are saying, you can't use my copyrighted work, which is protected by law, without my license. Now you say I will take a license from somebody, I will not take a license from somebody. The explanations are what they are. But net, if the statute itself recognizes that if the basis of your use itself is unauthorized, everything that's, well, it's like fruits of the poison tree.
Yes, I got it.
Everything then, yes. And which is why, Maloj, unlike the US or the UK, and that's the distinction we were trying to make, and that's why, Maloj, the US court categorically says you bought the books, therefore it doesn't matter. Here, you may have bought the book, but the minute you convert it into a medium which was not authorized, you're out. Now it's in that. Now please have section 51 for a moment. In that backdrop, Maloj, to contrast what the statute mandates. Yes, I'm sorry, Maloj, that last bullet is 51.1, not 50. When is copyright infringed? Well, I'm sorry, the last bullet on page 1 says 52.1 proviso. It's actually 51.1 proviso.
It should read as 51.
51, yes, I'm sorry.
Okay.
51 says when copyright infringed. Now this is also deeming. So copyright in a work shall be deemed to be infringed. And please just have, Maloj, the proviso in the interest of time. Provided that nothing in subclause 4 shall apply to the import of one copy of any work for the private and domestic use of the importer. Otherwise, Maloj, subclause 4 imports into India per se itself is a violation. And then please now have the explanation. For the purposes of this section, the reproduction of a, and again, Maloj, I emphasize, the reproduction of a literary, dramatical, musical, artistic work in the form of a cinematographic film shall be deemed to be an infringing copy. So there are two parts, Maloj. So the statute says whether I buy it, I can buy it abroad. So I have legitimate access to the product. Whether I lawfully acquire it. If I bring it into India, even then, so it doesn't say, it says work. It does not, similarly to like 52, it just says work. It does not say infringing, etc. For the purposes of this section, the reproduction of a literary, dramatic, musical, or artistic work in the form of a cinematographic film shall be deemed to be an infringing copy. So again, you may have access to A legitimately, but ultimately, if you use it for a purpose that is not authorized by law,
Guys, why are we getting into all this which have nothing to do with
only for one reason. Only for one reason. Because all of this goes back to one point. Either they say it's available online, so therefore I am entitled to use it. It's number two, I may have bought it, therefore I am entitled to do what I am doing it with because I am training my software. The statute is, as far as I am concerned, the statute says you can only use my work for the purposes for which I have authorized you to use it.
Correct.
First, I have not authorized you to scrape. That itself is infringing. Your act of storing, which you say is transient, in fact is infringement for the purposes of the act because it's one, storing, number two, it reproduces.
See, according to me, the controversy in issue is limited, restricted.
Yes.
But just by getting into reading every other provision in the act in support of the interpretation is just complicating things
But
unnecessarily.
may I just make that one point? And that's why, Manoj, if your lordship will just have...
We know which sections we're dealing with, but if you're going to say every other section in the act to come to an interpretation which uses the word cinematograph and all, then it does not.
I was saying something slightly different.
Yes.
The principle underlying this entire exercise is only because, Manoj, your lordships rightly then formulates that this is a question of law. My friend's entire defense is what I am doing is permissible. Why? Because of two reasons. One, because it is fair dealing within the meaning of 52. Number two, I am legitimately entitled to use this because I have access in ordinary terms. Why? Because it is publicly available. You have put it out there. So my objective only was this. The act of my putting it out there does not mean that you can do what you want.
Till there I'm
sum
with
and
you.
substance.
No, till there I'm with you. But now to read something about a cinematographic film
Only to make one point, and that's the only reason I was laboring that point, where the law wanted you to have the ability to do something different. Whether you acquired it legally or illegally, or it was available in the normal domain. So you use an infringing copy, but you do something which is in the larger public interest.
But it's for they will argue that this is only for cinematography.
I'll leave it at
It's
that.
not there.
I'm sorry, Manoj. In fact, I'm sorry. Again, so I'm not clear. The point I was making was only this. 52 itself is the repository of the carve out. either they show your lordship that they fall within.
But I don't think we can refer to 10 other sections to interpret 52, no?
I'm sorry,
Was,
it's the only reason was because 52 uses the expression infringing copy versus lawfully acquired. So the argument is, even if you purchased my book,
where does it use lawfully acquired and infringing
so
copy?
52 does not.
Yes, that's...
If your lordship sees what 52 says, okay, one second. 52 means, if your lordship notes, it says fair dealing with any work. Now, if any work includes an infringing copy, then I'm out. So the first copy has to necessarily be, as a matter of law, under the Copyright Act, something that is lawfully acquired. And even if it is lawfully acquired, the point I was trying to make was the statute imposes limitations in certain cases. But in any event, because it doesn't need to clarify that for 14, 14 says if you have lawfully acquired my book, it doesn't mean you can make a movie out of it.
Now, how do you get this interpretation that 52.1a
Yes, miss.
has to be lawfully acquired? Let's read it again.
Yes, miss. I'm not even saying that. I'm saying 52.1a says these acts shall not constitute an infringement of copyright.
Correct.
So far, so
Correct.
Because the explanation to 52.1,
Yes, let's read that again.
yes, miss, now says the storing of any work in any electronic medium for the purposes mentioned in this clause, including the incidental storage of any computer program, which is itself not an infringing copy for the
So
purposes.
again, though that phrase, that's why I told you, no, we should cull that out.
Yes.
because for our purposes, computer programs not involved.
Yes.
So we will just read till electronic medium for the purpose of mentioned in this clause shall not constitute infringement. Right.
What I was trying to make was, the statute says,
Oh,
if you
infringing
use an
copy, you're
infringing
getting.
copy, then you are anyway in violation. That's the point. The language used by the statute is different. Ultimately, all of that leads to only one point. The statute uses the words like lawfully acquired.
See, infringing copy exception has been carved out for computer program.
Yes, miss.
That's how I read it.
But please see, because if you use an infringing copy for fair dealing, you are anyway in violation of my 14 right.
That's okay. Whatever your arguments on.
That's all. That's the only point I was making. So here, Manoj, and the carve out for computer program your lordship sees is part of a very broad amendment which seeks to address certain technological aspects. So there is an overemphasis of that aspect. But the question is, Manoj, does it mean that you are entitled to do it? Because the flip side would be, I can use any non-infringing, I can use an infringing copy for this purpose. So therefore, lawfully acquired and infringing copy, these are two different terms. They have two different consequences in the statute. Where the statute wanted to use those words, they have used them
And
differently.
none of them are there in 52.1.
That's all. That's all. That's sub. Now, para 4 of my note. And this is where the argument merges. This act of scraping, according to them, is permissible because it's available in the public domain. The storage of this infringing copy, which is available in the public domain, the fact that you reproduce and download and store is infringing.
Yes.
So the storage of a publicly available copy is infringing. So therefore, it becomes an infringing copy. Or the purposes enumerated under 52.1a itself would amount to infringement. That's the substance. But please therefore see, if I were to read that down to say that works which otherwise infringe are permissible because I am fair dealing, then you would effectively then equate infringement with lawfully accessed or lawfully acquired. That would be in the teeth of the legislative intent of 14. That's the only point I want to make. 14 is my privilege. I can authorize you to use A, B, C. I can say you will not do D. Merely because I am silent on D does not mean you get a license to do D. Then, how do I test it in the facts? They say regurgitation. There is a glitch, but be that as it may. The fact that regurgitation existed and according to us is still capable of being done leads to a basis of, according to us, principle called reproduction stroke memorization. So you can't reproduce unless you've memorized. If you've memorized, you have my content. You can split it into tokens and vectors, but at the end of the day, the ability to reproduce is infringement. Then, Mr. Ramanujam had referred to the judgment in InfoPack, where a mere extract of 11 words was held to come within the right of reproduction in InfoPack. Now, the next bullet, not the defendant's case, that they have validly purchased copies or taken a license.
Sorry, which bullet are you reading?
I'm on the second last bullet under 4 months.
Yes. Yes.
It is not the defendant's case that they have validly purchased copies or have taken a license. Copyright in a work is therefore not exhausted due to its public availability.
Right.
Distribution of copy is recognized because I have the right to distribute and disseminate. And I control how it is used. Allowing access without consent of the copyright holder will conflict with the author's right to distribute their work to those who lawfully purchase it. Because even if the first copy is legitimate and not infringing, it is immaterial. If such copy is being used in a non-transformative manner and for commercial purposes, it would still tantamount to infringement. But these are the exceptions under 52, and that's why I was laboring the other 52 points. Lawful, acquired, etc., are all indicia of legislative intent. I've referred to engineering analysis. There is Disney. I'll show your lordships 2 paragraphs from that judgment. And reproduction or storing, even at the intermediate step, the argument is I'm training my product, so therefore there is no dissemination to the public, it's all internal. Without consent amounts to infringement. Unless they've admitted to storing copy at the pre-training stage, they of course say it's deleted eventually. That's the sum and substance. But I'm taking the admission on the face of it. The fact of storage without my consent is effectively storing in any medium, which is my right. Even transient or incidental storage amounts to infringement unless covered by the fair use exception. Because MySpace deals with that, I'll show your lordships that paragraph. The argument of the defendant that storage or reproduction of content for the purposes of training is only transient, again, is contrary to the law laid down. Time is irrelevant. And in fact, in Sony, the court categorically says it's really qualitative, it's the quality and not the quantity. In any event, time is irrelevant beyond the point. I'll show your lordships that. Then your lordship has the last quantum is immaterial, that's Rameshwari. Rameshwari, if your lordship recalls, again, the emphasis in Rameshwari repeatedly was not for profit, not for profit, not for profit. If ultimately, we must also see that in a particular context, it was education, there is a carve out in 52 for teaching purposes, etc. So, whether Rameshwari can even be brought to bear in the facts of this case is another aspect of the matter. They say that their LLMs do not store text, leave alone verbatim copies of various works within them, whether token or vector. And this is there, I've just reproduced their 2 versions. When ChatGPT answers a query using the search function, the information presented will not be a substantial verbatim reproduction of a content obtained from a web search. Attribute the relevant source along with a URL. Because all of this again is theory, because at the end of the day, as your lordship says, if I have an op-ed and I ask ChatGPT to speak about Mr. X's views in the public domain, if ChatGPT reproduces chunks of my op-ed and replaces a word or two in the overall scheme of things because it has learned to read my expression, but ultimately the expression is mine and that is protected. And is there infringement or not? So to some extent, my handicap is a matter like this can never be argued in vacuum because of the fact that it is fact specific.
So why are you not in court, Mr. Ram?
We will be. No point reinventing the wheel. Fortunately for us, we would have been, but for the fact that your lordship said crystallized question.
Current plaintiff is the front for all of you.
No, in fact, fortunately, your lordship's formulation of those, yes. The formulation of those questions, which applied as a matter of in rem determinations, helps us also, because otherwise your lordship would have been flooded with multiple cases and then each one would be with reference to a particular work. This exercise helps all of us to formulate and modulate our behavior. And like I said, the balance is this: the Copyright Act, at the end of the day, only requires what? There is protection, there is a remedy. If my content is worth copying, whether it is because you are reproducing or because you are teaching your module to act in a particular manner to make it easier for somebody to understand what is said by me, all that is required is a brief license. And if I'm being unreasonable, the law provides a remedy.
Right.
On that delicate balance, the statute always errs in favor of the copyright holder, and that is why 15 is so broad and 52 has to be read narrowly. However, the admitted fact of regurgitation and the form and format of the output itself is proof that your lordship will ignore Path General's interview. It's not on the record. I was just... Amal's conversion, again, according to me, is irrelevant because at the end of the day, that itself mandates 3 things: downloading, storing, and then reproduction in any form, in any medium. But according to the defendant, tokens and vectors only copy the non-expressive element of copyrighted material such as grammar and syntax. US court in Cadre, which Mr. Lal read, observes that grammar, syntax, word choice are all part of the creative expression and cannot be regarded as non-expressive elements, as they are inextricably linked to how people express their ideas. The court concluded that even though LLMs may learn about statistical relationships, those relationships are the product of creative expression. Unfortunately, Malas, there is material that we've placed on record which says that even this bogey that all of this is automated and does not have human intervention itself is negated by studies on the subject, and we've placed some material. I'll just show you lordships that. I'll just go very briefly. To say, at some point, Malas, we are dealing with a machine. The machine will not know the difference between a photograph, an article, a book, a poem, more importantly, whether A fits here, B is. So there is some amount of human intervention that is necessarily warranted to enable that program to learn what it does. Label, even this entire business of annotating, vectorization, etc., has human intervention.
No, the software development has to be the human.
I'm so grateful. No, that is one, of course. One is writing the code. The other is to also tell the code how to fix, how to recognize A or B. So the material, the underlying raw material has to be classified. You have to teach it. There is, again, public domain material which demonstrates how people in parts of the world were paid money to just go through and do this exercise. And they say, listen, we kept getting exposed to photographs we didn't want to see. But that was the nature of our job. But those again for another day. The defendant claims it does not employ humans for tokenization and vectorization. These are all statements across the bar. We are, of course, at a very preliminary stage. Training process does not require a human being to read or even view training data in advance of training. Again, according to us, this is belied by contemporaneous public records. Now, training of ChatGPT using copyrighted works and the output generated by ChatGPT obviously cannot be considered in isolation. And that's why I go back to that first line. Fair dealing, not fair use. For personal, private use, stroke research. So I can still understand, and even there, perhaps you are on the narrow margins of the law. I have bought books across the spectrum. I find that it's easier for me to digitize those books internally for my use internally, and nobody else, not even my junior has access to it. Even there, I may technically be violating the law, but a court may look around and say, all right, for the purposes of this, because it's personal, private, therefore I will probably not. But if I then start pushing a little more and say, all right, but you're now using that to save yourself the time that it would take you to go pick up a book and read. And you are now going to turn out 5 opinions as opposed to 2. Are you reducing the amount of labor that somebody has to do? We go down that path. It's in that backdrop, because it is reliant to a large extent on my work and the works of others, some of it copyrighted, some of it not. If I am unable to discern the difference at a very prima facie stage, but the admission is I have looked at your work to generate or at least improve the quality of my product. Then, the next question is the output derivative or transformative? If it is derivative, then, you are in violation. It is per se not transformative, at least as things stand. And prima facie, the admission is there are instances where it regurgitates. If it deletes the minute you learn, then there is no question of regurgitation per se. Therefore, SCC Online, and there's a very interesting passage from the Eastern Book Company's case, which I'll show you lordships. Further outputs from ChatGPT as far as expression of news is concerned is not transformative, no modicum of creativity, because we cited some law there. Then, of course, the next point is commercial purposes. I'll just flag that point, I'll leave it there. Then, the other balance.
Yes.
The statute says if your conduct is prejudicial to my interest, that also becomes a factor, and that's why I say law keeps pace with changing times. It is one thing for somebody to say, Mr. So-and-so is so good that he can read 50 books in a month, and he remembers all of it, and he doesn't really need to go about it. He can speak to the world at large, but that's one man doing.
So this is a classic case where a law which was last amended in 12 is trying to keep pace with the technology which is developed in the last.
Absolutely. And which is why if your lordship recalls. So fortunately, the law has three principles, and some of these are principles-based legislations to the extent. The principle is the owner of a copyright has the exclusive right to do or not to do, but for. If the but for is therefore an impact on the owner's ability to or being disincentivized to create, then it goes against the grain of the statute. It's in that backdrop, Malats, applying it to the facts of news. We are now at a space where news was first the province of newspapers. Then came the era of digital news, and somewhere along the way, Malats, paper has shifted to electronic. Digital news then has become short digital news. And somewhere, Malats, all of us rely on the visibility and the fact that somebody comes to me directly, because that eyeball becomes the source of my revenue and the ability to survive. Today, Malaj, if somebody says, please don't waste your time, I will then make you get it. And what am I doing? I'm doing three things. I put a footnote and I say, go to so and so. That's the argument your lordship heard. I am not copying. I am saying news about this. There is I hyperlink or I bookmark, and you can go to the original source. 8 out of 10 times, Malaj, the fact. This is what Google did, Malaj. Google said, come to me, and then started, Malaj, narrowing the scope of the page, and then we saw what transpired. We've seen that happen in the past in the context of ordinary rights. This is a case of a monopoly granted by statute. Therefore, Malaj, today, it does three things. You make me irrelevant to a large section of the population. Why? Because he can go somewhere else and get exactly what I have done, because somebody has the ability to take my work and then modify it slightly and give it to them. The fact that he does so while infringing my rights in 5 other manners is a separate issue. That's the first plank of the argument. But that's the thin element, Malaj, that your lordship may also keep in mind. And therefore, Malaj, my third bullet here. Perusal of 51 and 52 would reveal that the statutory scheme guards against substitutiveness and commercial exploitation, especially when it prejudicially affects the owner of the copyright. And therefore, Malaj, for somebody who admittedly licenses material from a few, for whatever reason, and I'm just flagging that as a fact, which is admitted, that's to say, I don't need to take it from you because of A, B, C, D, E, F, three of which prima facie are problematic. The rest, Malaj, are questions of fact. Where does that leave us, Malaj, is the short question. Now, Malaj, just a few judgments, if your lordship will permit me. That compilation, there is your lordship's record.
Yes.
Plus, your lordship has my written submissions, Malaj.
The DNPA's compilation.
This is the DNPA compilation.
Yes.
This is in IA 2199. In IA 2199, it's my there's a final compilation of documents, which is the main index. The first judgment is Richard Catry, which Mr. Lal had read.
Yes, so which one do you want to?
Well, I just wanted to show your lordships one paragraph in Catry. Well, if your lordships will only note, just on licensing, please have page 10.
No, this is one of those recent ones. No.
Well, this is that. Yes, Palaz. This is.
No, this is one of those two which have recent.
One of the two.
No, so let me just see the copy of Mr. Lal. I
Very
want to mark multiple.
Sorry, then I'll just give your lordships.
Yes, just tell me where was.
I have it in Mr. Lal's case. Document 27.
Document
27.
1987.
It's in that just two paragraphs. Your lordships have internal page 10 of that, if your lordship will have.
No, 27 is some paper and article.
No, that perhaps is your lordship is looking at mine.
Yeah.
Look is the IMI.
Where is you find that?
IMI document 27. Page 19.
No, it's been filed. Where would I find in the pleadings?
The pleadings. IMI compilation, IA 4027.
I don't know. Just figure that out. He gave me a hard copy. Did he give me a hard copy? No.
That was a soft copy. Surprise, 27.
Indian music industry compilation.
No, but you must have used it on the last date of hearing. So where is it located? In the court file.
In the court.
Yes.
In the court file.
There on the board.
No,
No,
there.
where?
Just see. Let's check.
It's not in the IF only.
Perhaps 4633 in the same PDF is what I
Sorry.
4633. Sorry, Manoj, we should have had that.
Yes, intervene a
Oh,
document.
document. Okay.
The intervene a compilation.
This is in there. I believe it's a file called 05 Documents in Support 4633.
Or anyway, anything else? We'll come to this later.
I'll just read it out. Manoj, just like I said, 4 lines from this. At first, Meta wanted, this is page 10 of Richard Cadry, internal 10 of Richard Cadry. At first, Meta wanted to license books and so tried to negotiate licensing deals with several major publishers. Meta's head of generative AI discussed spending about up to 100 million on licensing. But as negotiations proceeded, Meta realized that licensing would be more difficult than anticipated. For one thing, then it goes on to that aspects of the matter. And the court effectively says at the end of all of this that they acknowledge that this was the right thing to do, but practically there were problems. In our case, the statute has a remedy. So you can't not avail of that remedy, but only the last conclusion, which was read, but just because we are news publishers. This is page 39. The line which says, for instance, as discussed above, it seems that markets for certain times of works, like news articles, might even be more vulnerable to indirect competition.
Are you reading that?
Well, if your lordship has the middle of that, about 8 lines from the bottom at page 39.
Conclusion.
Yes, miss, the conclusion. The paragraph it starts with, in cases involving like metas.
Right.
It seems like plaintiffs will often win at least so and so, so and so. Just about 5 lines below that. For instance.
Yeah.
For instance. This is about 10 lines from the bottom. The sentence starts with for instance at the left side.
Yes.
For instance, as discussed above, it seems that markets for certain types of works, like news articles, might even be more vulnerable to indirect competition from AI outputs. On the other hand, though, tweak some facts and defendants might win. For example, using copyrighted books to train an LLM for non-profit purposes like national security, medical research, might be fair use even in the face of some amount of market dilution. So therefore, that balance again, the larger public interest, the author's work interest being paramount, and the recognition that somewhere along the way, some places will become completely irrelevant, then there's no incentive. So we have physical newspapers disappearing. Online newspapers will also disappear. And then what we are left with is Chat GPT.
But physical newspapers have moved into the online space.
The lordship is right. But therefore, part of the reason is also because physical newspapers, the circulations have come down drastically because A, it is expensive. There is not enough reach, it's difficult. And I have to wait, for instance, in the Northeast, you get at least till for as recently as a couple of years ago, you got today's paper tomorrow. Now I get today's paper today at the same time as the world at large. But if it disincentivizes me from then going down news publishing digitally or reduces my ability to do so, and somewhere along the way, all of us suffer, and that's there is no incentive for me to do that. In the same vein, if your lordship then has, your lordship will just note super cassettes para 27. This is super cassettes Chintaman Rao. This is part of my final compilation of documents. Just the line, which essentially says that the purpose ostensibly or obliquely should not
para?
This is para 27. Coordinate bench. Mr. Sibal was making that argument, and it was noted by your lordships. The purpose ostensibly, I'm reading about 8 lines from the bottom at para 27, dealing with the right to reproduction in the context of 52(1)(a). The purpose ostensibly and obliquely should not be to write piggyback on the work of another. The focus of attention and interest of the producer, author of the work, and the viewer, listener should not be the work of another, but the work created by the person who may bona fide be using the work of another for the specific purpose of criticism or review or for any other work. But the caveat is, the work of another cannot be used for any other purpose. The copyright protected work of another cannot be used out of context. There has to be an intellectual input and an original mental exercise undertaken by the person bona fide lifting or copying the literary, dramatic, musical, artistic work, which should involve either the criticism or review of the lifted work or of any other work. Copying of the work or any other for any other purpose, such as to make one's own program more interesting, attractive, or enjoyable, is not permitted. You copy my work, you infringe my copyright when you download it and store, and then you use it to essentially generate traction to your website. That also per se, prima facie, is problematic. And your lordship notes page para 109 of super cassettes.
Page 109?
Yes, para 109. Well, this would be page 355 if your lordship is using mine.
Sorry, page?
355. It will be running page 355, para 109.
Yes. Yes.
About the middle of that paragraph, which is about 8 lines from the 9 lines from the top, it says it is out and out an entertainment program with some information, but the line is essentially, it is plain and simple a commercial exploitation of the copyright works of inter alia the plaintiff, super cassettes, and Yashraj films by the defendant.
Yeah.
The taking is substantial not only in quantity but even in quality. Even if one were to apply the test of transformative use and examine whether the work of the defendant is transformative and whether so and so, it is clear that the defendant India TV does not pass the said test, has merely lifted the copyrighted works of the plaintiff without any change. So much so there is no superficial, because those are on the facts of that case. But the principle is you can't profit off the hard work of somebody else. You can't piggyback on somebody else's goodwill. I'll show your lordship's Eastern Book Company. I'll come to that. And before I go, that my friend wants me to show your lordships Harper and Row Publishers, which is at page 416. If your lordship will have paragraph 12 at page 420. But this essentially, a paragraph which about 8 lines from the bottom, it says nation's appropriation of unoriginal and uncopyrightable elements encroached on the originality embodied in the work as a whole, especially in the realm of factual narrative. The law is currently unsettled regarding the ways in which uncopyrightable elements combine with the author's original contributions to form protected expression. Therefore, at the end of the day, the argument is you have facts and you have expression. You are now telling me that because you are news, the threshold is higher. But at the end of the day, if I can transplant what is there in yours, and it's facts, I have no quarrel about it. But ultimately, you take away my expression, and which is what Kadri says, that even the argument that grammar, syntax, etc. are not expressive, those are the fundamental elements. that comes in the way. Then your lordship will only have 2 more judgments, and let's then leave it at that. I wanted to show your lordships one document. Please have 1105 Disney.
Two six one. That's the applet. Yeah, that
I'll complete. Sorry?
That's the applet to that account.
Yes,
You need to go to 2614.
Because if your lordship will first see 2614, I'm sorry.
PDF page 261. At 2623.
1, 2.
Well, it's 2614 PDF at 2623. This is document 37.
This is from
37.
So that's straight away. Well, this is the order which is affirmed in the order that I was showing your lordship. But
No, so document 37.
yes, please. Is the district court order which is ultimately affirmed.
Okay.
So if your lordship only notes minutes at 2616, running page 2616, which is 2623 PDF. The submission at serial number 5.
Page
Because this will be running page 2616.
2616.
at PDF.
Serial number 2, no, there's no 5 there.
On the left side. I'm sorry, your lordship has PDF 2623?
PDF.
2623.
PDF 2623.
Yes.
And that is running page 2616.
Yes.
It's the second para which starts with vid angel contents. That case law regarding the reproduction right under 1061 draws a clear distinction between unlawful copies which can be viewed by consumers and lawful intermediate copies which cannot be viewed. Vid angel argues that since their intermediate copies are unable to be viewed by consumers, they are not copies as defined by the Copyright Act, and as a matter of law do not give rise to infringement claim. That's the argument. Whereas now your lordship sees what the appellate court ultimately says in this context. Please have PDF 1112. Lordship has minutes. Just one second. Because if your lordship sees a paragraph that says, indeed, vid angel concedes. This will be running page 1110. In fact, if your lordship will have the second paragraph which says we've had no previous occasion to interpret. So we begin with its text. See Hernandez versus William. The statute clearly identifies 2 acts that are non-infringement, not infringements of copyright. First, it authorizes making imperceptible filtering by or at the discretion of member of a private household of limited portions of audio or video content of a motion picture during performances or transmissions to private households from an authorized copy of the motion picture. So again, we go back to lawfully acquired, etc. Second, the statute authorizes the creation or distribution of any technology that enables the filtering described in the first provision that is designed and marketed to be used at the direction of a member of a private household for that filtering, if no fixed copy of the altered version of the FMA is created by the technology. Thus, the second act authorized by the FMA, i.e. the creation or distribution of certain technology that enables such filtering, requires the filtering be from an authorized copy of the motion picture. Indeed, vid angel concedes that under the FMA, the filtering must come from an authorized copy of the movie, but it argues that because it begins its filtering process with an authorized copy, a lawfully purchased disc, any subsequent filtered stream is also from that authorized copy. We disagree. So merely because your starting point is legal does not mean that everything else that you do subsequently is legal unless permitted by law. And therefore they say, the FMA permits the making imperceptible of limited portions, so and so during a performance, from an authorized copy of the motion picture. It does not say, as vid angel would have us read the statute, beginning from or indirectly from an authorized copy. So which is why, again, an exception must be read strictly, and therefore.
You don't start with an authorized copy.
And now, what they therefore say at And the reason, my lords, that is there, double one, double one. The second last para.
Yes.
More importantly, Weed Angel's interpretation would create a giant loophole in copyright law, sanctioning infringement so long as it filters some content and a copy of the work was lawfully purchased at some point. But virtually all piracy of movies originates in some way from a legitimate copy. If the mere purchase of an authorized copy alone precluded infringement liability under the FMA, the statute would severely erode the commercial value of the public performance right in the digital context, permitting, for example, unlicensed streams which filter out only a movie's credits. And therefore, it says quite unlikely that Congress contemplated such a result in a statute that is expressly designed not to affect a copyright holder's rights. Flip side, section 14, wides, again, same point. Your Lordships will just see. Yeah, just 1 second. And MySpace and Eastern Book, and I'm done. It's document 17. And so please have document 17, which is MySpace.
Mr. Rao, I have to rise in 5 minutes.
I'll just 2 minutes more and I'll finish. That's why I said, Your Lordship will only have MySpace's argument on transient storage is noted at page 1138. Absolutely. And please just note, my lords, what the court says at para 52.
No, where? Para?
Well, para 25. This is 1138. MySpace argues additionally that 52(1)B and C provided immunity from liability because transient storage for facilitation of sharing is permissible, and that upon a receipt of...
Let's see the finding.
Please have para 67 at 1163 in the interest of time. I want just please note para 52 also because it says it doesn't distinguish between virtual and physical space, but just in the interest of time, 1163, para 68, 67, 68. 68. This copyright report document number. 52(1)B and C refer to transient and incidental storage. Transient means any work which is temporary or impermanent, and incidental. These include cached data, web cookies, or any other like form of data which is generated automatically to improve the performance of the core function. The ECD under 13 refers to caching as so-and-so, performed for the sole purpose of making more efficient the information. While ISPs may generate cached content as part of the process, the content in question is of a different type. Hosting and storing data, as observed earlier, does not qualify to be referred to as incidental or transient. The nature of the data being uploaded is of a permanent type, one which is accessible whenever demanded or searched for. These are the major functions, and any storage which is of a temporary form, aiding in the better performance of the main function would be covered under 52(1)BC. Today, the ability to regurgitate, albeit with tokens and vectors demonstrates that you are ultimately storing my work in a different form and a different medium. Please then have document 14, which is the United States Copyright Office report on the technical aspects of this matter. Just please have 973. This starts at page 943. This is on the training and reproduction right. Somewhere there is consistency amongst the world at large. Most commentators agreed with or did not dispute that copying during the acquisition and curation process, which is what they are doing, implicates the reproduction right. As Professor so-and-so explained, the process of training generative AI models is generally preceded by massive amounts of web scraping that results in the creation of locally stored copies of millions or billions of copyrighted works. Although some commentators noted that data may be discarded, and I am underscoring that, may be discarded after the training process, that does not affect the infringement analysis. Moreover, public reporting indicates that major developers often maintain training data sets for use in future projects. Therefore, at the bottom, the training process also implicates the right of reproduction. First, the speed and scale of training requires downloaders to download the dataset, copy it to high performance storage prior to training. Second, during training, works or substantial portions of works are temporarily reproduced as they are shown to the model in batches. These copies may persist long enough to infringe the right of reproduction. And that's why that transient also is either it's there in a fraction or it is so essential for the software to function. That's the cache. This is not a cache. Depending on the model at issue and the specific hardware at right. Third, the training process providing training example, measuring the model. These are the next paragraph. As discussed in the technological background, the extent to which models memorize training examples is disputed. When, however, a specific model can generate verbatim or substantially similar copies of a training example without that expression being provided externally in the form of a prompt or any other input, it must exist in some form in the model's waste, which means it is memorized, it is stored, and that therefore can only be regurgitated. Last sentence. Sorry. My friend wants me to show your lordship that. Third, the training process, providing training examples, measuring the model's performance against expected outputs, and iteratively updating the weights to improve performance may result in model weights that contain copies of works and training data. If so, then subsequent copying of the model weights, even by parties not involved in the training process, could also constitute prima facie infringement. And then the last paragraph. In such instances, strong argument that copying the model's weights implicates the right of reproduction for the memorized examples. Like other digital files that encode or compress content using mathematical representations, the content need not be directly perceivable to constitute a copy. So you can call it a token or a vector, but at the end of the day, it is what comes here. And therefore, please just have, they note a distinction in category 975, the last para. And why, the court does what it does and what was not spelt out there. Page 975, the last paragraph.
I'm reading that. In that case,
complainant did not allege that the models could spit out actual copies of their protected works or outputs that are similar enough to be derivative works. In Anderson versus Stability, in contrast, court denied a motion to dismiss filed by a third party that was not involved in the training.
Here, for the court to form a similar view, you would have to rely upon the examples given by the plaintiff.
That is one, but the other thing that the admission by them that in 2 instances there was regurgitation. Today, your lordship is told that is a glitch which I have resolved.
Yes.
And therefore, whether a model's weights implicate reproduction, those are questions of fact. The short question is there is material, if your lordship has, in this why, the other is the OECD report on artificial intelligence.
All right.
Just one last page, your lordship will see page 1075.
1075.
Your lordship just notes, technology companies and platform operators such as social media platforms, search engines, and e-commerce sites are both sources of data for scraping and active participants in the data scraping ecosystem. These platforms often are frequent targets for scrapers because they host vast amounts of information, notwithstanding data. And please have the last paragraph. Data scraping affects creators and owners of IP protected works directly. Because I don't want to read the rest of it, your lordship will see it. I've otherwise made a reference to it in my note. So in substance,
let me finish giving dates in this. Yes. There's no further dates?
Can I just get 10 minutes on the next date to show your lordships that Eastern Book Company paragraph?
Mr. Rao, this is a never-ending story now. I think it's a big mistake getting the interveners.
I'm sorry,
it's just, no, and you
I'll put it in mind.
But your timelines also, you said 30 minutes.
Exactly 10 minutes.
No, it's very, no, the whole schedule goes haywire. It's not...
my note, I just wanted to read that one paragraph, that's all.
Anyway, is there anyone on this side now? Right, so then you are there on the next day. We'll give 10 minutes to Mr. Rao by the watch and
Hello, Mr. Sibyl, Mr. Lata.
Hello,
that'll be much later. No, we want to finish the interveners on this side.
Mr. Kapil Sibyl for one of the interveners.
All right. Oh, it's a completely Sibyl's.
Take
45 minutes.
All right. So give. I think we let's try and give 2 or 3 dates more. Give it at 3 p.m.